Bright, please, let's have you. Hello, Bright. Please unmute. Okay, we're just getting some little challenge with Bright's connection, but we surely should get that fixed and get to that immediately. In the course of the week, the NDC has been holding a press engagement, the series they call Moment of Truth. And during that, they raised a number of issues about the AGYA PA deal and spoke about how it was important to recover this money or a substantial portion of it to assist this country. How much have we gotten from the IMF so far? Remember the first tranche they brought us 6 million. So there's a lot of money that can do a lot for this country. Hello, Bright. We are asking if what the NDC is demanding is possible to recover. And they actually hint that if power changes hands, they will chase the individuals that were seen to be politically exposed, according to the corruption risk assessment that Martin Amidu did. Those who were politically exposed and were involved neck deep in the whole deal, that was said to suggest that this was a group of people, a cabal, that was seeking to create loot and share, typical and not the interest of Ghana. They say there will be prosecutions if power changes hands. Hello, Bright. We try to have Bright make his presentation first. Then on the back of the presentation, we will have this discussion with my guests in the studio. The NDC suggests that if we recovered maybe even just half of this money, it will take care of so much of our needs, very many of our needs. Hello, Bright. Technology just failing us this morning in this manner, but we will definitely get Bright back to be able to commence the discussion with him. Okay, I'll try and see how we get Bright as quickly as possible so that we begin the discussion. We certainly must begin with him laying the background and bringing all the facts, some of which you may have forgotten over the period, and what is the real thing at stake. The NDC in its press statement said that the John Dramani Mahama, if he's able to form the next government, will investigate the stinky 12 million AGYA PA scam, retrieve all illegal payments made under same, and ensure that all the perpetrators are prosecuted. The day of accountability is fast approaching, and no one found culpable will be left off the hook by the next NDC Mahama government. This is a solemn pledge and our charge to keep when, by the grace of God and the Ghanaian people, the NDC assumes the reins of government in 2025. He said, we call on the Ghanaian electorate not to allow President Akufo-Addo and his corrupt cabal of family and friends to install as president their Dr. Bawumia, whose sole mission is to cover up the many ills of this remarkably corrupt administration and insulate wrongdoers, including himself, from prosecution. Do we have Bright on now? Okay, right. Hello, Bright.
Hello, can you hear me now, Samson?
I can hear you very clearly. Please, let's go on.
Beautiful. Apologies for whatever it was. Thank you for having done a very good job yourself, laying out the context. That makes my work easy. What I'm going to do is maybe highlight on a few of the things that you do not stress on as much as perhaps we think is necessary for the conversation. Let's remember that officially, as far as the government's position is concerned, AGYA PA is still ongoing. That is, the government intends to still do AGYA PA, because the last set of communications that have come from the government in respect of this matter, that is before the MIF CEO spoke in Parliament, was to the effect that the government intended to power through with AGYA PA. You recall that when this current board of the MIF, the Minerals Investment and Income Fund, was being inaugurated, the Minister of Finance issued an instruction to that board that they should go ahead and do AGYA PA based on advice that they had received. They'd also issued a press release in which they stated as a ministry that the president had given them some advice on how to restructure AGYA PA and pursue it. So we have to bear that in mind. So those of us that are opposed to that transaction, for us, an ongoing campaign to convince the Ghanaian public that we must force the government to end this AGYA PA charade. And this is just a good opportunity to recap the reasons why we think AGYA PA is such a problem. The first issue was that the way Parliament was treated was indicative of the total lack of respect for accountability that characterizes projects like AGYA PA. There were 5 agreements that were sent to Parliament, in addition to some additional subsidiary matters, and they were sent to AGYA PA, to Parliament on the 13th of August. So these matters were laid before Parliament on the 13th of August. You know the way the parliamentary process works. Committee, after it's gone through a number of processes within the committee, it gets to the main house, there could even be debate, and then it's passed. Everything was done in 24 hours to approve AGYA PA. From 13th August to 14th August. Everything, 5 agreements, major agreements involving the 97% of the royalties in the mineral sector of Ghana. Because in Ghana, gold constitutes 97% of the mineral royalties that we earn. At that time, manganese is picking up, but in those days, 97%. And then you have a transaction of this magnitude. And we have the sovereign parliament of Ghana sitting on it. And the government forces that parliament within 24 hours to approve it using its majority in parliament. That is the context. Remember also that before we sent this matter to parliament, all the processes had already been undertaken. In fact, the government did not intend to send it to parliament until the Attorney General prevailed on the government. So we had already set up this Asase royalties in Jay-Z. We had already begun process of hiring people and all of that. And so it was very clear that this was completely a formality. It was a mere formality sending it to parliament. There was no need, as far as the government was concerned, to ensure that there was sufficient review by the people's representatives. And that's a very important point, because I'm building up to a point. Secondly, people say that everything that the Attorney General said was addressed. That is Honorable Gloria Kufu in those days. That is not correct. Read her assessment of the agreements of 22nd July. This was basically less than a month before the matter was sent to Parliament. And read some of the concerns that he raised about stabilization clauses. Essentially, we have used AGYA PA to create conditions in which whichever company bought these rights that belong to the people of Ghana would have very limited oversight within the Ghanaian jurisdiction. And the Attorney General raised that very clearly. And if you read that 22nd July letter, it was very clear that she saw that the entire arrangement was to the detriment of Ghana. Those issues around stabilization, those issues around perpetual term, the fact that the agreement had no fixed term, no fixed length, essentially because it's tied to the leases where the gold is produced. Every time we discover new gold in those places, those gold resources immediately fall within the purview of AGYA PA. And the Attorney General felt that did not make sense. There should be a production cap. If it's 1 million ounces of gold that we are selling for it, let's be clear, so that it does not become an albatross around the neck of Ghana perpetually. That was not addressed. That was still in the agreement, that the agreements that were sent to Parliament. Remember that after this matter happened and the corruption risk assessment had been issued by the special prosecutor, who did an extraordinary job, putting his own career on the line, putting his own political reputation on the line, to try and warn the government and the people of Ghana that this particular agreement had ingredients within it which would definitely lead to corruption. Despite all of that, what we were told in 2021 after the elections was that as far as the government's official position is concerned, the matter must go back to Parliament for further consultation so that AGYA PA can proceed. So that was where we were left off. It is not a case that there was any kind of suspension which renders the matter in limbo. Where we're left off is that the people of Ghana were informed that the matter will go back to Parliament for additional consultation, and then the project will be rammed through. Our argument is that AGYA PA is inherently bad. So forget these procedural matters that I've raised, forget these contextual matters I've raised. The concept itself is incurably bad. And the goal should be that we get the government to formally terminate it so that this albatross is removed from the neck of the people of Ghana. Why is it bad? We have a good sense of how much gold is being produced today and how much gold is being produced from those leases over the length of time. We pointed out clearly that when you look at the government's analysis, the amount of gold or the quantity of gold involved was not aligned with the reality on the ground. Essentially, what they had put in the analysis differed from what was really the facts. If you look at the prices, the average prices over time, and the analysis that we made that $1,800 was a reasonable price, have been borne out since then. Gold prices are today above $2,000. When you add all of that together and use standard financial techniques, you don't get $1 billion valuation. The government's argument is that, we're going to the stock market, so the stock market will value it. That was not true. The gold rights had not been placed in the company that was going to be listed on the stock exchange. It had been placed in a local company, which was the Ghanaian entity. And it was that entity that was being bought by the one that was going to the stock market. And that price was in the agreement and it's fixed at $1 billion. So when we said the whole thing had been undervalued, we're not simply preempting what will happen on the stock market. These were matters of law cast in concrete. Secondly, to simplify the transaction, think of it simply as selling the gold forward. We get a certain quantity of gold because we get 5% on average of all the gold that's produced in this country. Whether or not the company makes a profit, we get a fixed amount when gold is produced. Often we receive it in cash, but we could as well receive it in gold. And gold purchase program is a way in which that particular thing is made manifest, which is that we have a certain portion of the gold that is produced in this country. We want to sell that gold forward. So we want to sell it forward so we can get some money today. What is the implied or implicit price in selling it forward? That was the analysis. And the implicit price in AGYA PA was $200. As I've explained to you today, gold prices are above $2,000. So that already gives you a sense. Why is it $200? Well, why is it less than the market price? Less than the market price because we are getting the money today instead of in the future. So what you do is you compare it with other similar transactions and say, what was the implicit price of gold in those transactions? So we look at several transactions around the world where this principle of streaming, where gold income in the future or gold revenues in the future is received today. And we say, what was the implicit price of gold in those transactions? And we found out that in the case of Ghana, this country was being cheated because the price in our transaction, despite all the other advantages, which is that the volume is not capped. So anytime a new discovery is made, that gold is made available to the company. Despite all of that, we're still selling the gold for $200 into the future. You don't take something that is $2,000 and sell it for $200 without significant scrutiny. It requires heightened vigilance. Secondly, they said, but in the end, because we are building a company on the stock market, that company may appreciate in value, or at the very least, the market is wise and the market will know how much to value the company that owns the rights. And because we have some shares in that company, ultimately we'll benefit. The truth of the matter is that it's not the market that sets the share price when you are using book building in an IPO. In the book building process, it is the senior underwriters and the rest calling their friends in the financial industry, their allied contacts in the financial industry, and trying to set an indicative price, which is what the share debuts on the stock market. And people like Joseph Stiglitz, if you don't believe me, read Joseph Stiglitz. He is a Nobel Prize economist. They have looked into this in great detail and found out that very often the possibility that those underwriters will underprice it is very high. Why would they underprice it? because they are selling to people they like in the beginning, or people that they are in close business relationship with in the beginning, before the shares get into the stock market. You sell it to them that way. When the shares do open on the stock market, you get a huge pop, is what you call it. So you get a huge appreciation, and that money goes to the people who set up the deal, not to the people of Ghana. Because ultimately, that price always comes back down. We looked at a lot of streaming companies which are listed on the stock market and shown the trajectory of their stock prices. Invariably, almost 90-something% of them had seen a pop and then significant depreciation. So even this thing put it on the stock market is not an efficient way to do what we wanted to do, and I'll prove that in a second. Secondly, because the underwriter sets the prices and allocates shares and the rest of it, there's massive room for collusion. Now, coming back to the picture of the money that you have mentioned, the $12 million, there are 2 points to bear in mind. One is that IPOs are very expensive. Putting a company on the stock market is very expensive. Nobody doubts that. In fact, one of our reasons for thinking that AGYA PA was very poorly thought through is that the argument was that instead of borrowing money or doing what in the trade is called securitization, where you have some money in the future, but you take the money at present, and the person lending you the money takes control of the future income. That transaction, the argument was that such a thing would be too expensive and using equity would be better for Ghana. So we said, what is the implied price of this transaction? Essentially, what is the implied interest in the arrangement we are making? Because what we are doing looks like borrowing money, because we are taking the money up front, and then in the future, money that will have come to us will go to someone. That's very similar to interest. If we had done that in the normal markets and we had gold and just a collateralized gold transaction, because we have gold income in the future, like we did with Esler and the rest, we could have done a deal for maybe 6% or something like that, because it's fully collateralized. Now, here is the challenge. In AGYA PA, we're going to get $500 million. But because it's an IPO process, we're going to end up spending within the range of between $36 to $45 million if the transaction had ended. So you take that out of what you were going to get, and that gives you a sense of the interest that we would have incurred if we had gone the AGYA PA route, instead of simply going to the market, saying we have some gold, we want some money up front, give us that money and collateralize it to the gold. It is like 3 or 4 times more expensive going the path that they took than simply going and borrowing the money. And that's very important. The second thing is the fact that in the current complaints that have come forward since this disclosure was made about how much we've spent on AGYA PA, we forget the fact that this is not everything. The underwriting fees have not yet come. So when you look through the list, you see that all the investment banks and those kinds of things are not yet mentioned. Those monies will be paid if AGYA PA goes through. But the question is, have we paid them any money, or have we incurred any liability that has not been disclosed? So all the Merrill Lynches and all of those things that you were hearing, all those investment bankers sitting in London you were hearing, were they doing this for free? That is not in there, because the argument is that it went through Imara. We don't have any disclosure of the full list of entities that Imara paid. That is why you don't see some of the Ghanaian investment banks and others that in their discussions, we all know were part of the transaction, African Legal Associates and the rest. You don't see them here because that full list is not yet out. We also argue that if this had continued and AGYA PA had been consummated, what will have happened is that Ghana will have lost control of its assets. So any future government will not be able to rely on, on mineral royalty income, which today is almost 30% of all our minerals revenue in the country. Now, you are going to tie the hands of a future government in perpetuity. Money that comes to the country and is used to fix roads and things like that. One government is going to go and borrow just $500 million and give it up for eternity using a stock market process, which will have led to a situation where the independent directors control everything and we don't know who these directors are. There were some option on the stock market to use the sovereign listing process. This government refused to use that process. They used the normal listing process. And when you look at the rules and the agreements that we were going to have, we forced Parliament to ratify. It says clearly that the power to take decisions, including how to spend dividends and things like that, were going to be in the hands of a very small group of directors who none of us have ever been introduced to. Secondly, because it was listed in this JC Trust location, we would never have known who the real owners are, because they will have used trusts, and by using trusts and nominee companies, there is no way you can go to the stock market and find out the real owners. So this notion that because of the stock market, we'll know who own it and etc. was completely misleading and completely untrue. In fact, there have been investigation in the US Senate and others, which we disclosed during the period of the advocacy, That shows that one of the greatest ways to hide ownership of equity was to use tax haven jurisdictions with strong secrecy requirements like JC, and then use trust entities where you put the shares through a trust entities, use nominees to disclose that to the stock market. Go and look at Atlantic Lithium, for instance, the company getting our lithium, and look at the list of owners. You see that they're all nominee companies. It doesn't mean that there's anything wrong, but I'm just saying that you will not see the owners of the company if you went to the stock market. That is not correct. And so we would not have known who controlled AGYA PA. More importantly than not, above everything else, we didn't do AGYA PA in 2020. It's now been 4 years. The amount of money we've generated from gold since then, just for the last 2 years, is 70%. If we count from 2020, we've already got the $500 million that we're going to get, and for that reason, was going to hold hostage gold revenues that future governments will use to develop this country. We've already ended since the 2020. If you take $150 million as the average royalties intake a year, that's $600 million. Why on God's good earth will we have gone to the stock market, taking $500 million, put our resources there, stack it somewhere in Jersey, under the control of directors that none of us have ever been introduced to, just for $500 million, and then claim that the 51% that we own will appreciate when other streaming companies have not shown that appreciation, and therefore the likelihood that we'll have even have got dividends ever was very, very threatened. How on earth will we have done that? That is the point. The issue is not just about the $12 million spent. More will be spent. We think 3 times more will be spent if this process continues to the end, because they have to now pay underwriters and investment bankers. And for that reason, and given the fact that we think it's incurably bad, the government must formally tell us they've stopped pursuing AGYA PA. That is the issue, Samson.
One or two questions for you. We know that in 2023, the ECOWAS court delivered a judgment in the matter that the CSOs, Transparency International, which was eventually disqualified in the process, Ghana Integrity Initiative and the Anti-Corruption Coalition of Ghana, the matter that they took before the ECOWAS court. The court gave a judgment in favor of the government. And we know that government communicators have used this judgment as a victory song, so to speak, to say that there was nothing wrong with AGYA PA. And so it confirms what they were saying all along, that you, the CSOs, were getting things wrong. For example, there were allegations that Gabriel Asarochiridako's firm benefited in excess of $2 million and so on. He came public to correct that, to clarify that. And he said that his firm got only about $103,000 and it was not paid by government. It was paid by the main transaction advisor, to his firm and not to him, so to speak. So what do you make of the point? This is sort of a good thing for the government to use as a basis to continue, that even the ECOWAS court has said the people don't have any case. I'll just read a small portion of that judgment at page 30, paragraph 76. It says the court is quick to state that the proof required in this instance of a claim for breach under Article 21F of the ACHPR is that the Commonwealth of the people of Ghana has been disposed of in a way that does not benefit them, thereby depriving them of it. The court had already stated that what this case was, it was a preemptive strike, and they didn't think that it was right to bring this case. Then it concluded here that what this court has before it are in fact evidence of processes that flow from democratic institutions and have gained approval from the people's representative, i.e. the parliament. So parliament had approved all the agreements. So why can you go to a court to want to set it aside?
Okay. So 5 quick points. One, it's important to remember that it's not all the CSOs that came together against AGYA PA that went to the courts. It was not there were like almost 40 or something CSOs that created the CSO on extractive matters. It wasn't all of those, that it wasn't even done in the name of that movement or that alliance. This was Transparency International and very respected local anti-corruption organization that decided that on the basis of the special prosecutor's investigation, they had a case.
That's right.
So that's number one. That's very important to clarify. So I, for instance, don't know anything about these proceedings. I didn't testify. I wasn't part of preparing it, etc. The second point to note is that it was brought only pursuant to the Human Rights Convention within the Regional Human Rights Convention.
That's right.
So this was not a matter that was looking into the propriety of the deal. It was looking about the human rights of Ghanaians on the basis that the assets, these gold resources, are part of our Commonwealth. And so have somebody's human rights been breached because the government wants to do this? That's very important to bear in mind. So it doesn't look as if a court has looked into the matters I have been talking about today, the financial propriety, etc. The third thing to bear in mind is that only 25% or so of the ECOWAS court's judgments are obeyed by the governments. So essentially, when the governments get a good deal, then they make a lot of noise about it. But the vast majority of judgments that are issued by the ECOWAS court are ignored by the governments. So if the government respected the courts in the way that they are trying to use the court as a means of legitimacy, then they would enforce the judgments of the court, which they don't do for the most part. The fourth point to note is that the basis of the arguments was what you lawyers know very well, which is the principle of subsidiarity. If there is some other entity where the decisions are best taken, another entity, typically higher up, will not interfere unnecessarily. Secondly,
the political question
like
doctrine.
Executive, yes, where there's also a basis on which a part of the government has taken a decision, courts do something we call deference. Now, look at what happened in Ghana. The government used its political power to pass this through parliament. As I explained to you, it was in 24 hours, 5 agreements. Something, you were a lawyer, a simple will, or a conveyance, something like that. Will you be able to do it in 24 hours? If you were really being serious, then to consider 5 agreements to dispose of access to this magnitude or of this magnitude, doing that in 24 hours. But the fact of the matter is that it's not the duty of a regional court to impugn the democratic institutions of Ghana, particularly given that all of these matters happened based on the treaty. There's an ECOWAS treaty. The treaty limits the functions of regional institutions versus governments. So if a government in Ghana has sat down, gone through all the processes and managed to use law to achieve a particular end, you think a regional court, based on the Human Rights Convention, is going to try and overturn it? It's not going to happen.
Right.
So we did not expect, that a court of that nature will try and stop something like that. Even Ghanaian courts perhaps will not, but I think the people of Ghana should.
Right. My second question is, when the NDC demands that there ought to be recoveries of the $12 million spent, is this something, a demand you think is reasonable, and it is something that can happen?
The demand flows from that extraordinary work that the special prosecutor, Honorable Martin Amidu, did during that period. That demand flows from therefrom. The government's response, the special prosecutor's corruption risk assessment, was extremely legalistic. It, in effect, tried to prove that because powers exist, those powers can be used anyhow. So, for example, a deputy minister can sign because the law allows that to happen. We went to parliament and got an amendment, etc., etc. That was not the basis of the special prosecutor's assessment. It's about the fact that everything was done to ram this through, even though it was against the interests of the people. And there were reasons, as I've given, some of them that I've given, that suggest that AGYA PA could be a conduit for massive corruption, the way it has been designed. That matter was never addressed. Look at the Ministry of Finance's response. Read it carefully. They don't tackle any of these things. Everything they did was to try and establish that they had a power under law to do the things they've done, and they've done them. So if the NDC makes an argument on broader strategic grounds, as well as on ethical grounds, and say that we don't think the way that these monies were spent were in our interest, and that they want to recover it from the companies and the rest of it, of course, it will be very complicated because you have contractual matters and you have a state party, you have these private companies. We have not seen the agreements. The starting point for the NDC will be to call for the agreements between all of these entities and the subsidiary agreements between those companies and all the subcontractors, not all of whom have been disclosed. That's number one. Number two is to ask for the compliance history of these companies, because they were still set up in Ghana, in Jersey, etc., etc. What is their compliance history? Number three, to ask for the liabilities that are still being built up. Because remember that whenever you set up a company, there are compliance costs that continue. I think the NDC can do a much more systematic job before it gets to the point where it can do recoveries. It needs much more information.
And I asked that question also bearing in mind that once there was no listing on the London Stock Exchange by the 31st of December 2020, the agreement had lapsed.
But the agreement can be reinstated, because within the agreement were provisions that allow for reinstatement of the agreement based on mutual consent of the parties. But remember that, who are the agreements with though? A lot of the agreements were structured between AGYA PA in Jersey and AGYA PA in Ghana. People forget that. Some of them, of course, structured with state entities like the MIF and the Bank of Ghana and others. If the government insists that this is a good thing and it wishes to reinstate those agreements, it can reinstate them by having those agreements re-signed. But the point we are making is that the whole AGYA PA idea is incurably bad. We should not take all the most assured income. You know why I say it's the most assured income? Government gets royalty money, whatever happens in the international market and whatever happens to the companies. The rest of the money we get, corporate tax and the rest, are dependent on volatile factors. For that reason, every government in the future can only rely on the royalties when it comes to real forward planning. So to take all of those, sell it forward at $200 an ounce, and use that money for very little, because $500 million is not going to do much for you. As you explained yourself, Samson. What will $500 million do for a country like Ghana, where at one point last year, we're getting $23 billion in forex throughput through our banks? $23 billion of forex in the first half of 2023 went through our banks. This is not a country that $500 million can make a material difference to. Why will you sell forward our goal for $200 an ounce when it sells for $2,000 today, just for $500 million?
Right.
It doesn't make any sense.
My final question to you briefly, you have done and have been consistent about the assessment and how we are selling Ghana cheap, our royalties cheap in this respect.
Yes.
Beyond that, you know, some of the things that actually got the debate very heated and suspicious was the involvement of the law firm of Gabi Asare-Chidako and the role of Yao Osafo-Mafo's son. Is it not possible to look at things from the way you look at them without looking at the individuals that are politically exposed and allowing that to cloud, you know, the opportunity of a fair assessment of the process?
So as we've stated, the procedural lineage of this entire transaction is contaminated. The way it went about, you know, forced through parliament, etc. The special prosecutor did an extraordinary job. It was a very technical piece of work, but most people are not taking their time to read it, to uncover procurement bid rigging, which in this country is very hard because of the nature of our procurement institutions. The PPA will approve anything you send to it if you are politically powerful enough. It's a completely worthless institution at this point. So when you use the PPA law and things like that in the current institution and the rest, you can get any result you want. What the special prosecutor did was to extraordinarily and excellently unpack that procurement rig agenda. And some of that was exacerbated because you had politically exposed persons. I'll give you a simple example. Why can you claim that? How can you claim that AGYA PA was being done in our interest as Ghanaians? And up to today, nobody has ever disclosed the directors of AGYA PA. You, Samson, you are a very prominent journalist in Ghana. If I ask you who are the directors of AGYA PA, do you know? If I ask you who are the officers of AGYA PA, do you know how they got there? How was this conferring recruitment that they said somehow managed to land on the desk of the son of the senior presidential advisor? You know, you ask a company, a global company, look for the best Ghanaian to manage this, and they look across the country. They find someone, another investment banker, no background in minerals or mining, hasn't run an IPO company before, etc., but somehow is politically exposed. I think all of these matters must be properly inquired into. How did they recruit those people? They said they paid $1.5 million to them already, the staff of AGYA PA. You don't take $1.5 million of a struggling country like this and distribute it among so-called directors and officers. that the country don't know about, whose credentials have not been explained to us, and how they got the job not explained to us. So I think there's a basis for that assessment as well. It's just that we were focused on AGYA PA in and of itself.
In
one, all Ghanaians have yet got into.
In 1 minute, some of the viewers have sent messages, and they are making a comparison between this and SML. Is that a fair assessment to do?
Yes, because the procedural history of SML is very, very dangerous as well. How do you come to a conclusion that 0.75% of all of Ghana's minerals and $0.75 every time we sell a barrel of oil should go to a company, when that particular company was a mushroom company? It was set up in 2017 by with no history at all in revenue assurance, in the line of work for which it's supposed to be doing. All the revenue assurance auditors in Ghana who have been doing revenue assurance work for telcos, for mines, etc., we didn't find any of them. Somehow we managed to source a big contract like this to a timber merchant and entitle that timber merchant to 0.75% of all our mineral revenues. How much does the government get in royalties? 5%. A company, just because it's going to help us do some auditing, gets 0.75%, and we don't know who these people are. Up to date, nobody has been able to show us who the founder of SML is in terms of or in relation to their capacity and competence for the assignment they've been given. Why do we do this to ourselves in this country? We have to be able to be bold and tell politicians that they cannot take us for a ride. Explain things to us clearly, show accountability. Don't just do things and say because you have the power and the law is with you, you're on your side, you can do whatever you want. I don't think that's how you build a functional, sophisticated society of any kind.
Bright Simons, thank you so very much. Bright Simons is Honorary Vice-President of Imani Africa.